Okay, I'm going to take that as my sign that it is time to begin. Um, Thank you all again for logging on to Labor Forward, hosted by the School for Workers. We do this Labor Forward series on a monthly basis to really highlight labor advocates and worker advocates, and the work that they're doing and the success stories that they have, so that we can all learn from one another. Today will be slightly different than some of our interviews, and that we're going to review some of the most recent moves by the new administration that have impacted labor agencies, federal workers, and the like. We all know that much is happening right now in the new administration, and it also, of course, impacts workers to a great degree. So let me first introduce Dr. Ahmed White, who is a new labor law professor here to the University of Wisconsin, and a labor law scholar. And I'm going to let him introduce himself a little bit more. But Dr. White, thank you so much for being here.
Thank you. I prefer I should go by Mr. since I'm a veteran. But thank you for having me, and yeah, I'm happy to say a bit about myself. I just got here this past fall, and teach at the law school and teach in the labor and employment area, and I've been in the field for 25 or 26 years, something like that, and have focused more and more on the NLRB side of things. But I do teach broadly in the area, and I'm happy to be here and happy to talk about this most important of issues.
Yeah, thank you so much. And I'll just add, we're thrilled to have you on campus. We never did get that coffee, but we'll figure this out. So since you mentioned start mostly focusing on the NLRB side of things, why don't we start there? One of the first things we saw that impacted labor specifically from the new administration were the terminations of the NLRB general counsel, the NLRB board member Gwen Wilcox, and an EEOC commissioner. And I'd love you to share your thoughts about what happened, and maybe even the potential legality or illegality of those terminations.
Yeah, it's really important. It's also interesting. I just so happen to know some of the people involved in this, and I won't get into that. But that knowledge hasn't really, or my familiarity with these folks hasn't really shed that much more light on what's going on here than I've been able to get, from the media, and that in itself is significant. I mean, it's clear that there's a hostility from the administration towards these agencies as they were constituted under Biden. And maybe something even more longstanding than that. I mean, that much is quite evident. What is the game beyond that is a little bit unclear. Those of us who follow the NLRB know that this is kind of a two-edged sword, because it leaves the agency without a quorum, and it leaves, for the time being, intact agency decisions, NLRB board decisions that have been made over the years that presumably the business community and people who are in some respects more likely to support what's happened to the agency would not be happy with. But those remain in place because, again, without a quorum, the board can't revise its decisions here.
Yeah, so let me take a step back. I want to talk about that quorum issue and how it will impact workers. But when we have a new administration step in, it's not uncommon, say, for the new administration to replace the general counsel of the NLRB. What we're talking about today is that the administration also terminated the employment of a National Labor Relations Board member. Have we seen that before? Does the executive branch have authority to do that?
We have not. This is unprecedented, and it's I think fair to say legally questionable. The case on point hasn't been decided, but there are decisions like the Humphreys executor decision from 80 something years ago that seem to make clear that the strictures that were put in place limiting the ability to simply dismiss a board member were themselves lawful.
Right.
And so that would tend to suggest that this is legally questionable. I don't think anyone doubts that.
Right.
How it's going to be resolved, I don't know, but you're quite right. Dismissing the general counsel is not at all without precedent and probably on sound legal ground, but dismissing a member of the board and without any particularized demonstrations of or attempts to demonstrate some cause for doing this.
Yeah, and in fact, doesn't the act require that? Doesn't it say the president can remove a board member with cause after a hearing, something along those lines?
That's right, and here I guess what I say is here we have neither, not even in an informal sense, much in the way of any justification for what's been done here, and that's essentially parallel to what's happened with EEOC.
Right.
And I just don't know what's going to happen now. It is true that the NLRB, for the first sort of 6 or 8 years of its existence, was the subject of all kinds of intrigue and political pressure and wrangling between Congress and the presidency. But it did result, all of that, in some significant turnover in the composition of the board and in its politics. But at no point were people just sort of summarily fired, not board members. Others were dismissed, but not board members. And so, yeah, this is
Right.
it's quite unprecedented.
Yeah. So I'd like to touch on, and then we will move to the EEOC, but I'd like to touch on your mention of there lacking a quorum. So just for folks that are tuning in, I'm wondering if one, you could explain that, right? Like why it is we're not with a quorum and what that means, and then the impact that has. How will that impact the operations of the agency?
So the NLRB in the last 20 years or so has gone through something else fairly unprecedented, and that is a lot of vacancy, a lot of time in which there have been multiple vacancies. I mean, people come and go as board members, but because of some of the political conflicts regarding the board and its work, and the way that's been tied in with kind of partisan wrangling, there have been times when the agency the board, which normally comprises 5 members, was down to 2 as it is now. And back in 2010 or 2011 or so, the Supreme Court decided a case on the question, can the board essentially conduct its business as a board with only 2 members? And the court's answer was no, it cannot. And it was quite a mess because the board had decided a bunch of cases with only 2 members. And all of those were thrown into uncertainty, essentially invalidated. And now here we are again, through a combination of this firing and pre-existing vacancies with only 2 members. What's significant about that is to do with the board's authority as a board. So the agency has said that it will continue to conduct business as usual. And it is true that it does a whole lot of essentially ministerial work or administrative work on both sides of its 2 main functions, or involving both of its 2 main functions, the elections work or representation work and the unfair labor practice work. The problem is to do mainly with the unfair labor practice side of the board's authority, which, as many labor people know, is also essential to the workings of the representation side of the agent's job, because it's through unfair labor practice charges that the disputes regarding representation, elections and whatnot, are resolved. Unfair labor practice complaints can only be finally resolved and enforced if the board acts upon the complaints or the findings of administrative law judges. So some people are saying, well, the agency can still prosecute unfair labor practice claims and enforce its representation decisions through unfair labor practice proceedings, because the administrative law judges will still be working, the regional offices that prosecute these cases will still be up and running. But if you can't get final orders from the agency, from the board itself, then these things can't be enforced, at least the way the situation currently is. And so this is a problem, and it's a problem for anyone who relies on the board. It's also, though, and this was the irony that we referred to earlier, it's a problem for people who might want to change or overturn board precedents reached in the last 4 years or so, or 3 or 4 years or so, because the board can't do that either.
So if I can take one step back to just see if we're in agreement. So if workers are experiencing and employers having committed unfair labor practices, they'd file a charge, their regional office can still investigate, their regional office can still bring a case before an administrative law judge to establish that unlawful conduct. But say if the employer then appeals the ALJ's decision, the board can't do anything, so that's not going to go anywhere else at that point. Is that accurate?
Right. That's right.
Yeah.
That's my understanding of things. And of course, that's huge, depending on how long this goes. And I think, not to speculate too much, but I think if you're thinking about the broader significance of what's going on here, it's useful to remember that there are a lot of people who regard the agency as fundamentally illegitimate, or whatever it does. It's just fundamentally illegitimate. And I don't know what particularly the plan is here, but one effect of this, if it goes on for quite a while, will be to expand that perception of illegitimacy. And that is not to the agency's advantage. And I'll put it in historical context. When the National Labor Relations Act was passed in 1935 and the NLRB first created, it was very clear that a large fraction of the business community was intent on having the statute essentially declared unconstitutional and putting the agency out of business before it could even get to work. And they were pretty shrewd about that. They understood that if the agency didn't ever do any work, any meaningful work, if it never really got started, it would be a lot easier to convince the courts that it was unconstitutional, and a lot easier to undermine a political support for the agency that it might have had with the Roosevelt administration or with New Deal, with supporters of the New Deal in Congress. And so that's what they tried to do. And, workers effectively countered that. One essential component of that campaign, which many people recall, was the sit-down strikes. Were the sit-down strikes that kind of said, we're gonna give this statute meaning. And I think in that respect, helped ensure its constitutionality and its functionality. Now, again, I don't know the particular intention here, intentions at work here, but it is the case, I think, that the longer the agency goes, if this drags on for quite a while without doing its work, then the more exposed it becomes politically, in a context where it already is in disfavor in a lot of quarters.
Right. Yeah. And in fact, if I'm not mistaken, there's still litigation pending, suggesting that where the employer has suggested that the board's not constitutional. So they're really being attacked on a number of fronts, it seems to me.
That's right. And again, I don't have a crystal ball. I don't know what the courts are going to do, but I tell my students, I said, this is itself relatively unprecedented, and it's not beyond the realm of possibility that the courts will revisit these landmark decisions, including NLRB versus Jones and Laughlin Steele from 1937, that upheld the constitutionality of the act and a great deal of the New Deal along with that. But if nothing else, the courts in recent years have shown that they are willing to revisit precedent, including landmark cases. And so, yeah, this is an interesting time on the labor front, no doubt about it.
Right. One more thing on the board before I make sure we leave some time for other things. A half an hour is certainly not enough for what's going on in the world. And that is the general counsel memorandums. I understand that general counsel memorandums that had been issued by General Counsel Abruzzo have been overturned. I'm just wondering if you can speak to that and sort of what impact that has on the agency
Yeah, I
and
don't
on
have a lot to say
workers.
about that. I just noticed that the other day, a sort of listing of some of the things that have been done. And, these have taken on more significance, I think, in recent years than they had before. So it's not surprising that this would happen. Um, I'm just not
Okay.
surprised to see that this has happened. But of course, they're not insignificant because they give in unfair labor practice cases and all sorts of cases, they give guidance um, to other board staff about what to prioritize, about how to frame these cases, and that's quite important because the agency handles 20-some thousand cases a year, and it's labored under a burden of inadequate resources for decades now. That's true of all the agencies. They can't do all of the cases they want to do with the same emphasis, and so they have to prioritize. And so one of the subtle but very significant ways that these kinds of these memos matter is by shaping these priorities in enforcement in a context where you gotta decide which cases to emphasize and which not to. And that can have make as big a difference as saying, oh, handle the case this way versus that way.
Yeah, thank you. Thank you. I do want to ask you, it's not just cases under the NLRA or enforcing NLRA violations that we've seen changes to. So I'm wondering what thoughts or comments you might have on the similar termination of of the EEOC commissioner, also bringing, I believe, that agency below quorum, if I'm not mistaken.
So that agency, I don't know that as much about what's going on there, but I do know that, yeah, people have been fired from that agency as well under similar circumstances where it's not clear the president has the authority to do this. Now the effects are not apt to be or positioned to be poised to be as significant as on the labor front because of private right of action. And on top of that, because of the proliferation of state EEO agencies that have taken on the duties of the EEOC. So with NLRB, there's essentially no private right of action for the vast majority of things that you can claim under the Act. So it's either the NLRB or nobody. With employment discrimination, which EEOC handles, fortunately for litigants, there is a way to proceed, and it's typical, either without the EEOC at all, through the state agencies, and ultimately, in most cases, through a private cause of action. But again, it's not insignificant because I think let's just say what conspicuously accompanies these decisions is a great deal of displeasure with the expansive view of the discrimination laws that the fired commissioners were subscribing to, and also, it's not as much of a hated institution as the NLRB is, but there are people who and powerful interests who would probably like to see the agency refashioned and restructured in what it does. And so it's really interesting and tragic for people who've been caught up in this. Don't get me wrong. I don't mean to present this in academic terms, but I would be remiss if I didn't say this is both very problematic, but also it's fascinating for someone who studied this, because I think we've gotten used to a lot of stability.
Yeah, the one thing with the EEOC that concerns me, I think is a better word, it's not adjudicatory like the NLRB, so it doesn't have the same kind of impact directly on workers' claims. But the EEOC commissioners do set guidelines, interpretations, and policy. And so losing that avenue, I think, will have an impact. And we've certainly heard from the administration on their views of discrimination claims and the like, right?
Yeah. Yeah, I agree with that for sure. And they have a robust tradition of issuing that guidance. And it made it a priority, and now it's not going to happen. And certainly it's not going to be along the lines that it has been. And I think to put all this in context too, with respect to both of these agencies, what's really notable here is this is the kind of culmination of kind of building tide of volatility. When I was just a kid then, but when Reagan, looking back on what happened there when Reagan took office, people on the labor front thought, oh, there's going to be a bloodbath. That he's going to put people in there. The one president who was a union president, he's going to put people in there, did what did to the air traffic control workers and all that, and it's just going to ravage the labor movement. Well, his boards did make some significant changes in the law, but nothing compared to the kinds of changes you get now between different boards in the last, really, since Bush 2. And this is kind of the culmination of that one board gets in there, does all this stuff, and then the next one gets in and says, well, we have to fix that. And it just becomes, it's almost like a wave that builds upon itself, and sort of it just becomes more and more pronounced each time. And in some ways, this seems like the culmination of that. And will it lay waste to this agency, the NLRB in particular? I think anyone who's certain that won't happen needs to think again, because all things are possible at this point, I think.
Yeah. So I'm just to follow up on your point, I'd like to. So in my practice over the years, right, we certainly did see, and I just want to flesh this out, make sure I think I understand your point, but the NLRB board members are appointed by the president, confirmed by the Senate. They usually they complete their term before they get removed or move on. And so we do see, as the executive changes, we see some slight shifts in interpretation and what kinds of decisions we see come out of the board. And so throughout my career, people have said, oh, they flip-flopped again, they flip-flopped. But what I hear you saying is, yes, there has been some differences in how different boards have approached and interpreted the National Labor Relations Act, but what we're seeing more recently is much more pronounced in terms of taking different positions.
Yeah, I think that's true. And I think that's true, and I don't know where it will end. I mean, I think in some ways this is the culmination of that, the kind of politicization of a board that is inherently political, don't get me wrong, but where the politics have become more pronounced, and the acrimony and all of that. And I'm not one of those people who says, well, that's the fundamental problem. I think that's symptomatic of the conflict that inheres now, in the level of conflict that inheres in labor relations now. The stakes in board decisions and other actions by the agency are great.
Wonderful. So because time is ticking, I'm going to shift on you a little bit and see if you have any particular comments on the termination or what's happening in terms of the federal workforce, so our federal employees.
Yeah, I don't know a lot about that, but I sort of share with many people the sort of doubts or uncertainties about not just the politics of this and the equity of tens of thousands of people already, but also the legal bases of what's happening, the way in which it's being done. A lot of these people are obviously civil servants, and that raises all kinds of questions whether the applicable procedures have been adhered to, and they're all government employees and enjoy, as we know, at least some modicum of due process protections. And likewise, First Amendment protections where that might be applicable, where people are claiming they've been dismissed for what may be improperly political reasons. It too is kind of unprecedented. This it's like the New Deal in reverse instead of
Yeah.
Great
Now we are
Society.
seeing legal challenges to all of this,
Yes.
so we don't, of course, we don't know what will happen.
And and a lot of the challenge, one interesting thing about the challenges is to do from an employment and labor standpoint with how the challenges are going to play out. So some of the unions have tried to challenge this, and recent decisions have been determined not to have standing. But an obvious difficulty here, and it goes to the sort of nature of employment law versus labor law, is this is exactly the kind of thing you want to litigate on a broad collective scale, given what's happening, because to do so case by case and all, it's just, it just compounds the mess of the thing, I think. And where it's going to end up, I don't know. I mean, I've taught law long enough to know that the courts have, in theory, the final say on these things, but they are political entities as well. And and predicting or trying to imagine what they'll do, I think it's crucial to bear that in mind, that they're under pressure here as well. Their legitimacy is at stake, their political standing is at stake, and they're being buffeted in all kinds. They won't say that, but they're being buffeted in all kinds of ways here. You want to think they're going to do what's right and what the law prescribes, but again, been around long enough to know that isn't always the case, or that doesn't
Not
happen in a vacuum.
Yeah, fair. I might have one more thing, but I wanted to see, Angela, if we had any questions from any of the participants. I'm getting pretty late here.
Nothing has come in yet.
Okay, if folks have something, please do take a moment to type that in, and we'll see if Mr. White can handle that for you. My last question would be, I had mentioned in something I had, communication I had, that another concern is the determination of inspector generals. And I don't want to get into inspector generals. They exist in different agencies oftentimes, and we know that we did see one get terminated from the Department of Labor. What's the point of having an IG in an agency like the DOL, and will that termination have an impact, do you think?
I honestly don't know. I mean, I have to think it's intended to have an impact.
Yeah.
Or it wouldn't have happened.
Sure. I mean, I guess my take on it is that in general, the inspector generals are supposed to be independent, right? And they're kind of a check and balance on what the agency is doing and ensure that what they're doing is compliant with law. And so we will lose that extra sort of check. Yeah.
Well, and that's, that to me is quite interesting, that side of it, now that you mention it, because of course the politics behind a lot of what's happening here is supposed to be about the legitimacy of these agencies and how they operate. And let's just say that there could be a bit of a contradiction between staking out that position and then doing something that exacerbates in the agency the very problem you say warrants your attention in the first place.
Yeah, excellent point. That is interesting.
The independence of the agencies.
Right, absolutely. Okay, I actually do see a couple of questions that have been put on. So where to start? I'll start with Harry, who asks, what happens next if there's no NLRB enforcement? I think you've touched on this, right? That like at this point, that means that the case is not over. And so there's no final decision to say, take action against an employer under the act. Would that be fair?
I think so. Now, the way these cases play out typically is there's a great deal of delay and lead time anyway. So there's no reason to kind of stop the presses if you have a charge pending or you plan to file one. because it wasn't gonna be resolved overnight. And, you know, the agency's been here before. It was in the early 2010s when the Supreme Court pulled its chain about the quorum, and eventually the board was reconstituted, or a quorum was reconstituted, and the cases were resolved. I don't know what the Trump administration is planning to do if,
Right,
and so,
right.
but for now, yeah, you know, there's a potential for this to be sort of hit, for the agency to be hamstrung, and for this to go on for a while.
Yeah, thank you. I do see one question that someone is asking, why can these orders, and I think we're talking the executive orders as well as perhaps some of these terminations, be acted on when their legality is in question?
Well, that's the thing. I mean, that's the question that's going to be resolved here. And, you know, I would be remiss if I didn't say that these independent agencies have always occupied a kind of constitutional netherworld. You got Article 1, Article 2, Article 3 that establish, you know, the basic parameters of the three branches of government. But then you have these agencies that kind of operate in between them. They share different executive, legislative, judicial functions, and they don't have a clear home there. And the courts have been tolerant of them, but there's not a lot of clear constitutional guidance. And that includes over the question, who controls them? And that's something that the Trump administration is asserting, that and sometimes in, you know, in pretty, let's just say, straightforward language. Well, you know, they get to decide this. And one issue here that I know a number of critics have tried to alert the public to, is that Congress has not really pushed back on this, and the courts are handling these innumerable cases that challenge presidential authority here, but the Congress hasn't said, you know, we're a branch of government too. We set up these agencies. It's up to us to decide if people are let go outside of the parameters or the processes that we set up. But of course, the Congress is controlled by the president's party, and that's, I think, clearly part of what's going on here.
Yeah, that's interesting, and I don't want to get too deep into this, and I'm over time, but I'll just connect that we had one question saying, well, what would we ask of politicians regarding all of this? And it seems to me that if Congress is not asking that or acting, that might be one thing that you would ask of your electeds, right? Is to act on something that you think may be problematic. Is that a fair?
Yeah, I think
political.
I think so, but I think that, you know, putting aside whatever sort of partisan commitments one might have, is if the aim here is, for better or worse, to fundamentally change the way, say, the NLRB does business, or the way the labor law is enforced, then there are certainly congressional ways of doing that, or ways of doing that by legislation, that, you know, people in Congress might assert, that yeah, they to whatever end, if it's to radically restructure the agency, if it's to abolish it, if it's to strengthen it, whatever it is. And that's a process that, when it's played out, and I don't mean to exaggerate its rationality or coherence, but it's played out in a relatively rational and coherent way, with hearings and fact-finding, you know, and all this stuff. And this is happening, let's just say, precipitously, and that's left a lot of people questioning what's going on and where this is going to end.
Okay, well, I do want to be respectful of your time. I promised you a half-hour interview. This ending here is, you know, we're nowhere near to knowing where all of this will land. But do you have any other just general comments that you might want to end with?
Oh, just to reemphasize that, I just don't know what's going to happen, and you know, I don't mean to diminish, I don't want to diminish the human side of this, that a lot of people's lives have been turned upside down by what's happened here. beyond that, it really is a set of extraordinary developments, and
Right.
where it's going to end up, I mean, who knows? I think a lot of people on the labor side, not everyone, but a lot of people on the labor side have been raising more and more doubts about the efficacy, the functionality of the statute and the NLRB structure here. Well, and I don't want to judge that one way or another, that position, but it in some ways may be on the verge of being put to the test. By
Yeah.
unfolding here.
Okay.
We may be about to enter a kind of new era in labor relations. I don't know that that's going to happen, but I don't know that that won't happen.
Great. All right. Well, I greatly appreciate your time and commenting on some of these new actions. I'm sure School for Workers will have more information on all of these as we go forward, but thank you so much for joining us and for sharing your thoughts on this.
Oh, I was very happy to do so. Thank you.
Yeah, thank you. And thank you all for your attendance. Take care, everyone.